for Lori Vallow. She has a hearing this morning. I figured we can watch that until Monica Simontelli's trial comes on. So we have about 45-ish minutes that we can watch it. If it's anything interesting, I'll finish it up later after Monica's trial. I'm working on editing, so I'll be doing that and listening. Let me move myself more into the corner. It should be starting any minute. And I'll keep my mic muted most of the time because my other computer is working too hard and the fan is going on and it's pretty loud over here. Okay. pretty good about starting on time, so I would imagine that it will start any minute. lazy over the fact that it's late. I keep checking other locations just in case, but yeah, they just haven't started yet. took a little while.
Daybell and they've been exposed to something in the media about it, they should tell us about what they know about it and about whether they know about that other case and whether they know about anything that happened to it about it. So I anticipate losing a number of jurors just based on that. But I agree with you. Some may say they've been exposed to it, but it wouldn't affect their ability to be fair. And in individual voir dire, we can explore those options. I don't want to necessarily taint the whole pool by saying, hey, she's got these convictions in this other state.
And Your Honor, I don't propose we talk about the convictions, but we will hear the names JJ and Tylee in this trial. So that's my concern, is if we don't raise those names, whether or not we put them in the list as people that they may hear.
What I could do is on question 15, where it lists out my name, the court staff, I need to include your name, the attorney's names, the advisory council's names in there. I'll add those. But at the bottom where it says other potential witnesses, I could do a third or another category that says other people that may be referenced but are not going to testify and list those names. That's fine. Is there any in addition to those two?
That would be the only for that. I think the other issue is, of course, the defendant's supplemental 15.2 names.
When was that filed? I haven't seen it.
I filed actually 2 motions to preclude them all and emailed them to your court Sunday.
Okay, maybe that's in my folder that's on my desk. Before we
Defense filed that on the 12th of March.
Okay, before we get to that, let me ask the defendant. Other comments on the proposed questionnaire and the information that we're going to put in there?
I think it's
What's that?
pretty clear.
Okay, do you have any objection to listing Tylee and JJ because they will be mentioned?
No?
Okay. All right. Let's take a look here. Let me ask the state, you have 21 witnesses listed. I need to look at the defense witnesses that were listed. And we're after jury selection. I recognize jury selection could take longer than the initial week that I've set forth, but from April 7th to May 15th, the current screening, that is 20 full days of trial and 2 half days, so essentially 21 days of trial. Do you really think we need to screen that far out? I know you're being overly cautious.
I think, especially given that I'm not positive we'll pick a jury in that first week, I think we should, Your Honor.
All right. Defense have any comment on how we're screened through May 15th?
I think it's plenty of time, Your Honor, myself.
All right, let's deal with a couple things. First, I've received the notice of compliance. That was when the defendant requested the Gilbert video. Is that apply to the second case or this case?
Your Honor, it's an incident that occurred in January. It's not really, it was disclosed because it is mentioned in the DR. The defense had filed a motion for the state to disclose that, and then had brought up again on the 11th that the state had not disclosed it, that there was some YouTube video of that. I have looked for said YouTube video. I have gone through the police report. I don't know what video she's discussing, but we're not aware of any video that hasn't been disclosed. So I'm just providing notice that disclosure is complete as to that police report that is peripherally relevant.
All right. Any comment on that?
Yes, Your Honor. For clarity, is the state proposing that there is no video or that they don't have to give it to me because it's not attached to that DR number?
I think what she said was she's not aware of what video you referenced. So as far as her knowledge, she doesn't have it and doesn't know about it.
So I should go directly to Gilbert Police Department to get it?
Well, last time you were in court, you said your investigator or someone told you about it,
A mitigator
a mitigator.
showed it to me.
If they have that link, why don't they just send it to the state, and that may help the state determine if that's something they've already disclosed?
I will tell you why they won't, because that is my former team, and they will not do anything to help my investigator, my paralegal. They won't give us any information that they found. They won't talk to us at all because apparently there was a conflict. So they will not help us. They will not send us anything. They will not email us anything. They will not answer anything that we ask them to. So that has been the response from my former defense team. That's where we are.
All right. Do you know, and maybe your advisory councils can speak to this, did they turn over a file to you, or did you have to start from scratch?
No. From what I understand, all they turned over was the 22 terabyte hard drive, and that is it. They didn't turn on any notes, any work product, nothing that they had done to that point. Continue to stand by that today, even though a lot of that information I gave to them, they would not give it back to me.
All right. I'm going to make an order, and it'll be in the minute entry that they turn over a copy of their entire file, including any mitigation information that was gathered to the advisory council. Ms. Hicks, you look like you want to say something.
I don't know. No, I'm good, Your Honor. Thank you.
All right, so I'll do a more detailed order about, they should have turned over a copy of their entire file to advisory council when they withdrew. All right, so I've read the defendant's disclosures that were filed March 6th and March 12th, as well as the state's motion to preclude. And, well, let me start. Have you received any response from the defense, anyone from the defense team since you filed this on March 16th?
Your Honor, last night at 10:30 or so, defendant's investigator sent over a list of the addresses of the witnesses. I did speak with him this morning. I still am unclear if defense will be setting up those interviews or if they will be providing phone numbers to the state to set them up ourselves. As for the expert, again, last night at like 10:30 at night, defense investigator emailed the state and indicated that the defense expert would need to or wanted to obtain the physical laptops and cell phones that the police had impounded so that he could then review them, do his own Cellbrite or extractions. So obviously the expert hasn't even begun work, let alone, they've also requested all impounded items from law enforcement. I'm unclear if they're asking for ones that were impounded in Idaho as part of their investigation or just the ones here. The statements from the investigator appears to be all of them, which would mean the state would have to request Idaho to send those to the investigator. So again, given all of those issues, I don't see how that it would be possible for the state to provide that to the expert prior to this trial beginning, let alone to get a report or an opinion prior to this trial beginning.
All right, let's set aside Dworkin for the time being. So you're, well, let me ask the investigator. What's your name, sir?
Jeff
Jeff what?
White.
Okay, Mr. White, are you going to be setting up interviews for the state to interview whatever potential witnesses the defendants noticed?
I'm trying to verify, excuse me, sir. I'm trying to verify the phone numbers to be correct. I do have a few of them, but some of them I'm trying to make sure that this is the correct numbers.
Okay.
I did the searches for them, and I have to apologize. I left yesterday, and for some odd reason, my email just did not go through. So,
Your Honor, my understanding is that the state has interviewed every single person on my witness list previously. That's where I got the people from the interviews that they had from the state previously. So I understand that they're allowed to do another interview of them, but they have interviews of every single person that is on my list, with the exception of one,
Which is who?
which is Nate Eaton.
Okay. When you say the state's done the interview, do you mean police or someone from the prosecutor's office?
In discovery, I have interviews with police on every single one of the witnesses that are on my list.
Okay.
So I know that they had their addresses. I know that we were trying to get the addresses to them in the quickest way possible. And where I am at the jail, the communication is very difficult for me to get a hold of my investigator, to get a hold of my paralegal. I'm 23 hours a day locked down. If I don't have Wi-Fi, I don't have a phone. If I don't have battery, I don't have a phone. I don't have access to get to people. So I understand the time constraints, and we're doing the best that we can of getting things answered, getting things put together.
So as a threshold question, your assertion is that all these people that you've listed in your notices have relevant information for trial?
Correct.
And do you know if the police have interviewed these people?
Your Honor, the
They may be
first
referenced.
listed person is a reporter. So I'm not really sure the relevance of a reporter.
He's the only one that hasn't been. So that's what I stated.
So, Your Honor, the point is to start with, one, these people, I'm not sure all of them actually have been interviewed. Those that have would have been interviewed 5 years ago. So whether or not their addresses are correct, unclear. It's not the state's responsibility for the defendant to do the defendant's work and find these people. I have an absolute right to do interviews just as the defendant does. So in terms of the witnesses, I think that most of them, as best I can guess, would be character evidence, which would be improper under 405. So depending on what they say, then I need to file motions to preclude or motions in limine for any or all of these witnesses.
All right, so it's premature to address these today. The state's going to have to interview them and find out if, in their opinion, they have relevant information or not. And then if there's a dispute as to whether or not they'd be called, I'll have to deal with that as it comes up. But if they're unable to be located or interviewed, obviously they won't be called at trial. Mr. Dworkin, if you want him to do extractions, you're not ready for trial. So in order for him to do the work that he's requesting, getting copies of a laptop or a cell phone or whatever the case may be, that's going to take him time to extract and analyze and then prepare a report, months maybe.
I understand that, Your Honor, and I'm hoping he can do it in an expedited manner. I requested him from OPDS on January 14th. He got approved on March 7th
Well,
from OPDS.
you're the one pressing for your speedy trial, so you kind of have to make a decision on, we're set for trial, you want to go to trial or you want to have him do that work that you want? Because I don't think both are going to happen. Even if you got the laptops today, generally those types of things can take weeks, even months to analyze and prepare a report on.
I understand that, and I also understand that I've only been given 10 hours for him from OPDS, right? So if he could spend 10 hours this week getting them ready, then he can give us a report with the best that he can do.
Well, the report's already late technically, but if it were allowed, first of all, it's going to take time to coordinate him getting let's start here. Specifically, what are you requesting? Because the state wasn't clear whether you were requesting items here impounded by a particular police department or items that may be impounded in Idaho.
Well, I'm sure that my investigator would like to have all of those things done, and I realize that we're on a time constraint, and I would be only concerned with one item, which is at Chandler Police Department, which was Charles, my husband's phone, Charles Vallow's phone. And I would like a copy of the extraction that they took from it. The digital forensic extraction from Chandler Police could be given to him immediately. That would be very helpful.
Wasn't that already disclosed?
Yes, Your Honor.
Was that part of the initial terabyte?
Yes.
Excuse me.
Yeah.
Everything that I have is on a 22 terabyte. So if
Hard drive.
hard drive. So if I give that away, I can't do my work.
Well, can't you make copies of files out of it?
22 terabytes.
I understand that.
Okay.
So what's your proposal?
I'll take it up.
I mean, if you have all that information in a file, I'm not saying you have to copy the whole 22 terabytes, but there's a file in there somewhere that's the Cellbrite extraction already for that requested item that's been in defense possession for however long now.
I'll take it up to Lonnie.
So I'm happy to make an order, but again, if he's not done with that information you want, are you still wanting to proceed to trial at the end of this month?
Yes, Your Honor.
Okay.
Do you know what's really fun? Making a website on Wix.
Hey, we're How Ridiculous, three childhood friends.
Well,
would
it
put
could
this-
still be precluded because depending on what his opinion is, first of all, it's late under the rules of evidence and rules of disclosure. And secondly, depending on what he says, the state would have to have an opportunity to consult with an expert as well. So even if he got something done, it could still be precluded, but I'll give him the opportunity to do whatever it is that you think he needs to do to analyze that. But that information's been in defense possession for months, if not over a year.
More than a year, Your Honor.
Yeah.
And he was just approved by OPDS last week, Your Honor.
I thought you said he was approved. You applied in January.
I applied for him in January and last Friday, he got approved.
Again, this is one of those things where you have to weigh your options on whether it's worth it to get a continuance so you can have your defense do the work that you want done on your defense. But if you're telling me you don't want to do that,
I would like to do that, but my situation in my housing department precludes me from doing that.
from asking for a continuance?
No, from getting things done in an effective and quick manner.
Okay. All right, well, so you're telling me you don't want a continuance, because any information he has at this point could be precluded as being untimely.
I understand that is the rule, and I understand how unfair and prejudicial that would be to me.
Okay. So I guess I'm gonna have to cross the bridge on whether these notice defense witnesses are even able to be located and interviewed before I make a decision on whether they have relevant information and can be called at trial.
Obviously, Your Honor, we have a little over a week to try to interview these people, so I will
understand.
file something at the end of next week indicating who I've been able to reach and interview and ask to preclude everyone else.
All right.
They also obviously ask to preclude them regardless,
Right.
based upon what they may say.
All right. What else do we need to address today then? From
Your Honor,
this-
the only other motion that we did not address last week was the state 609 motion. I presume the defendant will likely testify, so I didn't know if we wanted to address that now.
Are you prepared to address that now?
No.
I generally will, I guess I'll advise the defendant now that if you choose to testify, it's likely that the jury would hear about the convictions. But at your request, they could be sanitized, meaning that they would only hear about the fact that you have convictions, as opposed to what the nature of the conviction are. But that would be up to you, whether you want that information out or not. And then the jury would receive a limiting instruction that the existence of those convictions is only to be used for the purposes of determining credibility. So you should be aware of that when you make a decision on whether you want to testify or not. Oh, if you do want to testify, it will be question and answer, meaning you need to write out all your questions that you want to be asked and have one of your advisory counsels ask those questions to you when you're on the witness stand.
Right.
Okay, so you can't take the witness stand and just give a narrative. It'll be question and answer.
So am I supposed to reply to the 609? Is that what you're saying? And ask for it to be sanitized if I want that?
We can talk about that when we actually have a 609 hearing, but yeah, you can make that request orally. You don't have to do a written response. I indicated last time for your opening statement and closing argument and questioning witnesses that you'll pretty much be limited to the podium. We'll be in a different courtroom apparently for trial, but it'll be set up very similarly. Either your investigator or one of your advisory counsels will approach witnesses with exhibits if you have to show a witness an exhibit. So I'll have to do the same limitations on the state. The state would be confined pretty much to the area of the podium, and the state would have someone assist in approaching witnesses with exhibits and that sort of thing. All right.
I have some motions that I'd like to file. I've had a really hard time getting, my
copies
paralegal's
for the
very
state?
busy. I don't have copies.
All right, we'll make copies and give them to the state, and then we'll file them, and depending on what they are, I'll rule on them as the response and replies come in, or we may have to address them depending on what they are. So plan on that questionnaire going out. I think we said, next Thursday, the 20th, will be sent out to potential jurors for the first batch of jurors, and then the responses would be cut off on the 26th.
Judge is going to be sent out Monday the 24th and will end on Monday the 27th.
All right. And then I'll meet with the parties on the 31st to go over those remote responses. So that'll be the 31st at 10:30 a.m. Then again, I'll just reiterate on April 1, are we having we're not having walk-ins, Izzy, until the 1st?
Correct.
Okay, and then on the 1st, we will meet again, and for the rest of that week, we'll likely be meeting at 10:30 and continuing with jury selection every day until we get enough jurors. Hopefully, we get enough the first week. If we have to, we'll go into the second week.
Judge, I know that I'd given you a date that I was going to need to be dark on. I'm going to put out there, since I obviously don't know when we will get the jury picked. I do have some witnesses that are flying in, so I may have some days where I may need to end a little early or whatnot to try to accommodate some witness schedules. But I'll keep the court updated once we get a jury picked.
I think we'll have a good idea by about day 2 of jury selection whether we're going to need to go into the next week or not. That reminds me, though, is I would like the parties to plan on, we're going to have a much better idea after about the second week of trial and the first trial, how the second trial will unfold as far as how many jurors we might need, but I would like the parties to plan on doing another remote questionnaire with a much larger pool for the second trial and meeting on Friday, May 30th. I'm just giving you a heads up as far as this is concerned. And then for scheduling purposes, so everyone knows, I'm planning on probably going Monday through Friday of the week of June 2nd, as well as Monday through Friday the week of June 9th, to try to get as much done as we can. And then there's going to be some dark days there toward the end of June, but we need to get it done by July 4th.
Your Honor, when are you planning on starting that trial?
So jury selection would be starting May 30th. All right, anything else from the state for today? If you want to stick around, we'll get you copies of those motions.
I do. Your Honor, I guess the only other thing is, for the questionnaire, are we going to put in the defendant's 15.2 witness list?
I'll put in those names preliminarily. It doesn't hurt, just in case anyone is called from that list. And if anyone knows any of those people, I will put that in, actually. Anything else from the defense?
So I'm unclear on where we stand with the video that I requested.
The state says they don't know what video you're talking about. They've disclosed everything they have, so I'm going to make an order to your prior team to give you whatever that is. If you have a link in that information, you can forward it to the state so the state can see if that's something they've already disclosed or if that's something Gilbert didn't give them, or on the other hand, since it was told you secondhand or showed you secondhand, whether it's something different than what you thought it was. I don't know. So I'll make an order that they hand over all those things to you, so maybe you can figure that out. But at this point, the state says they've disclosed everything that they have and everything that they're aware of.
All right, so it's a shame they started late. I have to switch over to Monica's trial now. And one thing for Lori, I just really want to know, her hair is highlighted, right? I mean, I'm assuming that's her getting it done. How is she continuing to get her hair highlighted? I mean, it's not important at all, but every time I see her, it looks like her hair is touched up, and I don't get it because she's in prison. So if you know, let me know. All right, I'm hopping over to Monica's. Thank you for watching.